Buenas and Hafade, Guahusi Senador Telo Taitague. This public hearing is called to order, and the time now is 2 p.m. Good morning to you all, and to those who might be watching from home, and to those who are here who are participating in this committee today. Welcome to the People's House. For the record, today is Tuesday, April 22nd, 2025. This hearing will be conducted by myself, Senator Telo Taitague, Chairwoman of the Committee on Economic Investment, Military Buildup, Regional Relation, Technology, Regulatory Affairs, Justice, Election, and Retirement. To comply with the Open Government Law, notices of this hearing was disseminated to all senators and public at large via email and published in KUAM on Tuesday, April 15, 2025. And the second notice was Friday, April 18, 2025. Notice of this hearing was also available on the Guam Legislature's website and the Government of Guam portal. I would like to welcome my colleagues who are joining me today, and that is Senator Shelly Calvo, Senator Sean Gumatautau, Vice Speaker Senator Tony Atta, and Senator Vince Borja. Welcome. We have the following bills on our agenda today for discussion. It's Bill 23-38 COR and Bill 80-38 COR. But before we discuss these bills, I would like to set some rules of engagement for everyone to follow during these proceedings. I respectfully ask that we conduct ourselves professionally and respect others' opinions. When speaking, please make sure you speak directly into the microphone and state your name and the title for record-keeping purposes. I ask that the panel members to remain for any questions that my colleagues may have. Questions and testimony shall be confined to the substance or nature of the bill on the agenda. Individuals who do not comply with these rules will be removed from the room and prohibited from further participation. The first bill that we will be discussing is Bill 23-38 COR, introduced by my colleague Senator Shelly v. Calvo. It's an act to add a new article to Chapter 33, Title 15 of Guam Code Annotated, relative to establishing the Uniform Real Property Transfer on Death Act. Also, I'd like to bring to your attention that a fiscal note was also provided on January 30th, 2025, and it be granted a waiver pursuant to Public Law 12-229 as amended. Also, legal counsel has reviewed with no recommendations or changes to this legislation. And at this time, I'd also like to recognize the invitations that were sent out for Bill 23-38 COR. It was sent to the Judiciary of Guam, Department of Land Management, Public Defender's Office, and Office of the Attorney General. And at this time, I'd like to turn the microphone over to my colleague, Senator Calvo, to her opening remarks on this legislation. Senator Calvo, you're recognized.
Thank you, Madam Chair. Hafade buenas to everyone, everyone's here and my colleagues. Today, Bill number 2338 COR, the Uniform Real Property Transfer on Death Act, a measure designed to empower the people of Guam by simplifying the process of passing real property to loved ones without the costly, time-consuming, and often burdensome probate process. For far too long, families in our community have faced legal hurdles, unnecessary delays, and financial hardships, simply trying to inherit the homes their parents or grandparents worked so hard to build. Probate court proceedings can be stressful, expensive, and complicated, often taking months or even years before rightful heirs can assume ownership of a family home. In some cases, families are forced to sell inherited property just to cover legal expenses, leading to the loss of multi-generational homes and deepening economic instability. This bill offers a clear and effective solution, a transfer on death, TOD, deed. This legal tool allows a property owner to designate a beneficiary who will automatically inherit their real estate upon death without court intervention, delays, or additional costs. Unlike joint tenancy, which may restrict an owner's ability to sell or manage their own property, a TOD deed preserves full ownership rights during the individual's lifetime and remains revocable at any time. Additionally, the bill aligns Guam's laws with estate planning best practices seen in many states across the U.S. By enacting this measure, we ensure that our residents have greater control over their property, a more affordable estate planning option, and a faster, more efficient way to transfer property to their loved ones. This legislation is about protecting families, preserving generational wealth, and eliminating unnecessary barriers to inheritance. It provides our people with a simple, flexible, and legally secure method to ensure that their wishes are honored and their families are not burdened with avoidable legal battles. I urge my colleagues to stand with me in support of Bill number 2338 COR to provide a clear path to home ownership for future generations and to strengthen the rights of property owners across our island. Thank you, and I look forward to our discussion on this important measure.
Thank you, Senator Calvo,
Thank you.
for the introduction of this legislation. And all those who are listening on at home, you can also view this legislation on the 38th Guam Legislature's website under bills. And once again, this is Bill 23-38. And at this time, we have signed up from the Attorney General's office, I believe this is Attorney Lee Miller, to come and testify. Thank you, sir. Please state your name and your agency, and then you may begin.
Good afternoon, Madam Chairman, members. My name is Lee Miller. I'm the Deputy Attorney General in charge of the Civil Division. The Attorney General's office is here in support of Bill number 2338. It's a good bill. It's a good law. It already exists in many states on the mainland. It works well. Having said that, on behalf of my colleagues in the Bar Association, we do suggest that folks who choose to take advantage of the law invest a little bit of money with a lawyer or a real estate professional to really understand the nuances of what they're doing when they execute a transfer on death deed. And let me just highlight a few examples of scenarios where it's not necessarily obvious exactly what the outcome might be. For example, if dad passes, if mom and dad own their home as joint trustees, dad passes, mom will automatically own the home as her property. If mom then executes a transfer on death deed to her 2, 3, 4, 5 children, and she simply lists each of the children, but before mom passes, one of those children were to predecease, die before mom, the heirs of that child who predeceased mom have no interest in this particular property. The property would simply pass to the living brothers and sisters listed on the deed. Folks need to understand that if I execute a transfer on death deed and list my 3 children, 4 children, 5 children on the deed, I am transferring the property to my kids essentially as equal partners in the property. In order to deal with the property, to sell the property, to mortgage the property, to go forward with the property, the kids are going to have to unanimously agree on what comes next. And if they can't unanimously agree, the property stands still, waiting till we get unanimity. And just to reemphasize the point that I started with, oftentimes when we first buy a piece of property, as a husband and wife, we will take ownership of that property as joint trustees. That's the customary way. Not automatic, but the customary way. Husband and wife buying a house, buying a piece of land, take ownership in a piece of property. If for whatever reason, down the road, mom or dad were to sign a transfer on death deed and convey their interest in the property to literally anybody else, any of the children, any third party, the deed is really ineffective. If the joint trustee status will always trump the subsequent attempted conveyance of the property via the transfer on death deed. These are scenarios that, generally speaking, are unlikely to occur. But on the other hand, if you have a large family, especially if one has a family with brothers and sisters, not all on Guam, as I suggested, it would be worth spending a little bit of money up front to really understand exactly what the nuances are of the transfer on death deed, and making sure that the way you've filled out the deed form is exactly the way you intend to see the property move forward. Two final thoughts on this particular bill. Americans love to set it and forget it. You have a life event that causes you to update all of your documents, all of your affairs. You spend some time getting everything squared away, and then all is well. Years go by before another life event occurs, before you pass away. Just to give you one example from my own background, my long time ago, my father-in-law and my mother-in-law got divorced. A couple years thereafter, my father-in-law remarried to a wonderful woman. They lived together as husband and wife for a number of years. She took care of him in his final illness. She was a spectacular caregiver. But many years earlier, my father-in-law executed a piece of paper indicating that upon his death, his Social Security death benefit was to go to his wife, who he specified, named as his first wife. And he never, ever came back around and said, aha, first wife's out of the picture. I need to update the documents to reflect the second wife. And Social Security doesn't care. My mother-in-law received his death benefit, happily cashed the check, good for her. When all of us, and even my mother-in-law, would have probably acknowledged he probably really wanted his second wife to get the check, but that didn't really stop her from cashing that check from Social Security. The last comment I would offer on this particular bill is I would urge the legislature to make this bill even easier for the people of Guam to take advantage of by amending the bill to include a form of deed in the statute. Many states do this. That way, when you get the bright idea to want to clean up your personal affairs and you're like, well, what does this deed look like? What are the magic words? that I need to put in this deed. If there is a form of deed in the Guam code that people can literally just copy from that is legally sufficient, that is the simplest, most straightforward way for folks to get this done, get these transfers done correctly. With that, Madam Chair, I'm available for any questions. Good afternoon. This testimony is submitted on behalf of the Attorney General's Office and our client, the people of Guam, in support of the adoption of Bill number 2338, the Uniform Real Property Transfer on Death Act, into Guam law. The law has the potential to assist many of our citizens in finding an easier way forward following the death of a family member. This law already exists in many states, and we believe any concerned lenders, real estate professionals, and title companies may have were previously dealt with. The law builds on an effort in American law to design ways to pass property from spouse to spouse, spouse to loved ones, without the need of probate, courts, and lawyers. Anyone with a pension or retirement account already designates who gets the account funds upon their death at the time they open the account. Guam residents don't have to wait months for court hearings to receive the death benefit from a loved one's GovGuam pension. We do offer a few cautionary observations that could be eliminated if folks invested a little money up front in legal advice. People taking advantage of the Act should be aware of the language in Section 3382. If a property owner signs a transfer on death deed transferring ownership of the property to their 3 children, subsection 3382A2 says that if any of the 3 children dies before the property owner, then the property goes to the 2 surviving children. The beneficiaries of the 3rd child take nothing. Subsection A3 says that the interest given to the 3 children is equal and undivided. That means that all 3 children would have to agree to sell the property or how to divide it up. 3382C makes clear that if a husband and wife own a piece of property as joint tenants and one of the spouses later signs a transfer on death deed giving their interest to a child, then the joint tenancy will prevail and the child takes nothing. Section 3384 makes clear that persons taking property via a transfer on death deed don't get the property free and clear, not only of liens on the property, but also free and clear of other debts of the deceased. If the deceased had substantial debts at the time of their passing, the property transferred to the loved one via the transfer on death deed may still have to be sold in order to satisfy those final debts. To make this legislation useful for the people of Guam, we encourage an amendment to include a form of deed that people can copy. The purpose of the law is to facilitate our residents being able to accomplish property transfers without the need to pay a lawyer or other real estate professional. By including a form of deed in the statute, we make it as easy as possible to get that done. Americans love to set it and forget it. How many of us who work for the government of Guam remember that we filled out a form entitled Designation of Beneficiary when we first went to work? The name on that form gets our pension benefits upon our death, no matter what life change events may have happened, unless and until we change the name on that form. Laws that simplify who gets what in the future are great, so long as our wishes remain simple. Anyone who gets divorced later in life or who doesn't want their property to go in equal shares to however many of their children survive them should invest in a lawyer to draft the appropriate documents to reflect their more complicated wishes. The good news is that most of us lead pretty simple lives, and this bill is sure to be of great value to the citizens of Guam. We urge the legislature to enact it into law. Thank you for the opportunity to comment on this legislation.
Thank you, Attorney Milley. I appreciate you reading into the record the testimony from the Attorney General's office. At this time, I would like to open it up for the sponsor of Bill 23-38, Senator Calvo. You have the floor.
Thank you, Madam Chair. Thank you, sir, for your testimony. I was just going to clear away a few of the items that you have mentioned, which are they're duly noted. These suggestions from the AG's office, actually, we will be working on these things during the markup meeting. And just to mention that it's almost like currently when we assume properties, right? Let's say it was inherited, and the properties have lien towards it, or there's mortgage. It's almost the same. Where, because I know you brought up that concern about assuming responsibilities. So it's not something that it's already happening right now. So, but we will refine it during the markup, and I believe that you mentioned about a form. We do have a form that we will attach during the markup session. So these things are, I'm thankful for the guidance, and I take it seriously, and I want to tighten this bill so much that it will be a really good bill. But anyways, before we begin the question and answer, I just wanted to thank you again, and I wanted to just say a few remarks before the Madam Chair will open it for questioning. I'd like to take a few moments to reflect on why this conversation is necessary and timely. Bill number 2338 proposes a new legal mechanism, the transfer on debt deed, that would allow individuals to pass real estate directly to their chosen beneficiaries without the need for probate. To evaluate this proposal responsibly, it's important that we first examine how property transfers currently work in Guam and the challenges families face when trying to secure and retain their homes after the loss of a loved one. For many residents, especially those without access to legal counsel or formal estate planning tools, the probate process can be long, expensive, and emotionally taxing. It's not uncommon for heirs to face years of uncertainty or even lose property due to procedural delays or disputes. Understanding the scope and nature of these challenges, such as how many properties end up in probate, what typical timelines look like, and how the Department of Land Management processes property transfers, it is essential to determining how impactful and feasible the TOD deed framework would be for our community. We also need to take into account how this policy would affect vulnerable groups, such as elderly homeowners, residents with limited incomes, and multi-generational households, who may benefit most from a simpler, more affordable way and a direct way to formalize their intentions for passing on property. I sincerely appreciate your participation, the perspective each one of you bring to this important conversation.
Thank you, Senator Calvo. Senator Gumatauta, you are recognized.
Thank you, Madam Chair, and thank you, Lee, for being with us this afternoon. I only have a couple of questions, really, and let me start with the very first one. Recognizing that Section 3376 in the bill states that a transfer on death deed is non-testamentary, please clarify what will happen in the event there is a conflict between a transfer on death deed and a last will and testament. Will a transfer on death deed supersede a last will and testament?
Madam Chair, Senator Gumatauta, yes, the transfer on death deed will supersede the statement in the last will and testament. The transfer on death deed, similar to the designation of beneficiary that we typically fill out for pension accounts and insurance proceeds, things like that, as a legal construct, as soon as the original owner of the account passes, shazam, the assets immediately become the property of whoever the designated beneficiary is. And so even if there is a will and the will tries to pass the property to somebody else, the will is regarded as later in time. It's outside of the magical Shazam that happens when one passes. And so the transfer on death deed will prevail.
All right, thanks so much, Lee. And with respect to section 3382B in the bill, requiring a beneficiary to take the subject property inclusive of all conveyances, encumbrances, assignments, contracts, mortgages, liens, and other interests that are tied to the subject property at the transfer's death, what information is available regarding experiences in other U.S. jurisdictions where beneficiaries end up losing property that was conveyed to them because they were unable to assume the financial obligations that were tied to those assets?
Well, Madam Chairman, Senator, the beneficiaries of the transfer on death deed take the property essentially as if they were the previous owner. So to the extent the previous owner had mortgaged the property, promised the property as collateral for a business transaction or something like that, when the beneficiary comes into ownership, they come into ownership with not only the benefits but also the burdens that the previous owner had, and all those have to be worked through. And to the extent that the property isn't worth the claims that might already exist on it, as an attorney who's handled these types of transactions before, once our clients come to understand that the property is underwater, so to speak, we suggest to them that they sign something called a disclaimer deed, which says, which is another form of deed that says, well, that deed says I'm now the owner of the property, but you know what? No thanks. I don't want it because I don't want the obligations that go with it. And it's not just money claims. You know, there may be, it's not always a house or something like that. If you have a commercial property that's you know, run down, it's got environmental liability. There are many reasons why the condition of the property makes it something that the individual just really doesn't want to take on. And so, but that doesn't mean the property just sort of goes into limbo forever and ever. At that point, to circle back to your first question, if the transfer on death beneficiary disclaims ownership of the property and there aren't, transfer on death deed doesn't provide for a secondary or a tertiary beneficiary, then we go look at the will. And then we try and decipher, well, who is next in line, and do they want the property? Because we always want to make sure that somebody is responsible for the property. And so the law provides a number of mechanisms by which we can sort of sort through all of the potential heirs, you know, including the, you know, proverbial nephew in a faraway country who gets a call and says, hey, the uncle you never knew passed away and now you own this property. That's not make-believe. Those situations happen from time to time.
Right, so Lee, would you say it's very common then in the United States that these types of, I guess, policies would be in place?
Most of the states on the mainland have adopted the transfer on death deed law. It is a project of something called the Uniform Laws Commission. Lots of apparently smart lawyers get together and try and come up with something that uniform means they work very hard to try and make sure it works in every jurisdiction that recognizes American law, and this bill reflects their work product.
All right, thank you so much, Lee. Thank you, Madam Chair, for the time. Thank you again.
You're welcome, Senator Comitato. Senator Atta, you are, or Vice Speaker Atta, you are recognized.
Thank you, Madam Chair. You know, it almost reminds me of the payment upon death, right? You know, when you have an account at the bank, you have that payment upon death, and it just automatically goes to that individual. Interesting. Yeah, it's a good way to just facilitate movement of either assets or accounts. That perhaps maybe something that you think Guam should maybe consider the revocable living trust law as an option, or?
Madam Chair, Senator, you know, for many years, lawyers, real estate professionals, legislators have come up with a wide variety of ways to avoid this apparently horrible situation we call probate. And anybody who owns, frankly, much more than, you know, one house, a couple of cars, and you know, maybe some credit card debt. If that sums up your life, then all these simple, straightforward bills are perfect for you. But if your life is more complicated, you have a special needs child, or you have a multi-generational household, or you have a complicated business life, then yes, a trust is the most appropriate way to try and organize all of the pieces and parts of your life in a way so that they both move on to exactly who you'd prefer they move on to, but also move on with as little history, as little of that baggage being carried forward onto the next generation.
Yeah, that's good to know, because I think, you know, when we try to simplify methods and ways to, you know, move either property or even your savings account, and cutting the red tape is the best way to go. But like you said, I think when you have all these, you know, multiple assets, or even like you said, an individual with special needs that you may need, you want someone to take care of when you go, then perhaps the trust is a way to go. That's great to know. I learn something new every day. But thank you for that. That's the only question I had. Thank you.
Thank you, Vice Speaker. Senator Borja, you are recognized.
Thank you, Madam Chair. I have no questions at this time, but just want to go on the record to say I fully support this measure and commend Senator Calvo for introducing this thoughtful and forward-looking legislation. Again, I think really at the end of the day, this bill is about giving, you know, people a peace of mind, especially our Manumco, right, and making sure that the transfer of property or land can be handled with dignity and care. But yeah, thank you again to the sponsor, and I look forward to supporting this bill on the floor.
Okay.
you,
You're
Madam
welcome,
Chair.
Senator Borja. Thank you so much. I just have a couple questions as I looked at the section 3384 that you spoke about when it talks about property. And this is any kind of property. That means the TOD is a car, land, a home, or is this just strictly property in the sense of land and home?
Madam Chairman, this particular bill is strictly real property.
Real property.
You have a title to your car. You have a title to a boat, and there are similar laws, but not this one, that would allow you to transfer those types of assets upon your death.
Okay, so that being said, when you talk about you are now going to inherit any kind of debt that comes along with that property, we can assume that, let's say the individual, this is real property, that somebody has a car they just bought, they had passed away, they have a TOD on their house, their real property, and the individual who passed away also has a vehicle. And there's $30,000 more on that vehicle. The individual, just because they receive the home, doesn't mean that they have the debt on that vehicle, right? Because we're talking about you're inheriting real property and the debts of the real property. You're not inheriting a car that was, you know, still has a payment on cars, or maybe even a motorcycle or something else that is different from the real property. Is that what I'm assuming here, that this bill will only deal with debts of what you inherited from the TOD?
Madam Chair, no.
Okay, so it's different.
The subsection A of 3384 says that, and car debt is an excellent example. Perhaps an even better example is final medical bills. You know, if your loved one had a long illness, those final medical bills could be extraordinary, and the doctors and the hospitals and the pharmaceutical companies, they all expect to get paid. And so when you pass, there is a one way or another, either because you picked somebody to be responsible for your estate or the law picks somebody for you, somebody becomes responsible for cleaning up and closing out
The administrator, basically the administrator.
all sort of the last issues that remained upon your passing. And to the extent that there aren't enough resources in the estate to pay the final bills, whatever those final bills might be, the administrator of the estate has, under 3384A, can inform the child, best friend, whomever, that received the property via the TOD deed, sorry, we need some of the money
Proceeds.
proceeds that property represents in order to clear the
And then Mr. Miller, Attorney Miller, then who would be responsible to sell that property in which these heirs of the TOD received the property? Who's responsible to sell it and then provide the additional funding needed to pay off the debts? Is it the administrator's responsibility of the estate, or would it be the heirs of the TOD?
Madam Chair, it is the responsibility of the administrator to resolve and close out all the final claims of the estate. And to the extent, as the estate administrator, to the extent that the transferee of the TOD asset doesn't want to be cooperative, whatever cooperative means, in those instances, and I've had to do it myself, and then frankly you have to go to court and compel the TOD beneficiary to make a contribution.
Okay, that could be a lawsuit all in itself too if the heirs of the TOD do not cooperate in itself. The other question I have, that being said, is the time. Let's say my father had signed a TOD with giving all my siblings a portion, well, equal shares. But then there was a mistake with the name of one of them. It was, for some reason, there was a mistake. How can you correct that on a TOD? Do you just, cancel out, file it at Department of Land Management that this TOD has been canceled, and then you provide a new one?
Madam Chair, yes, that would be best practice.
Okay.
The legal rule is last in time wins. However, the best practice is that when you're making any change for any reason in a TOD deed, you should first record a piece of paper that says, I'm hereby canceling the TOD deed I executed on this day, and then right after they stamp that at DLM, then I hand them the new deed, so that years down the road, when all this becomes real and the property ownership has to actually transfer, it's unequivocally clear to anybody and everybody exactly what mom's intentions were, dad's intentions were. And again, that's why nobody likes paying legal fees, but it might be worth just a little bit of money to make sure you do it right when you're
Right. Okay.
cleaning this stuff up, so that we avoid the big fight
Okay.
in the future.
So it's as simple as that. And my last question regarding taxes, is there an inheritance tax, or does TOD void any kind of taxes from any of the heirs receiving from a TOD?
Madam Chair, full disclosure, I don't know if Guam has an estate tax or a transfer tax, but the general rule is no. You to the extent that the jurisdiction has a transfer tax,
Okay.
it's due and owing.
Just have to look it up then. Okay. Well, thank you so much for the opportunity to answer some of my questions I had. And yes, I think this is something, as someone who's gone through, probate, with my father's estate and the issues that came about without any will, without any, TOD, it did make it very difficult for my family to go through. So this is one step closer to providing simplicity, and it's almost, sometimes when I'm going through this, I ask myself, with my father's death, it cost me more, that he passed away, to handle all these things than what he intended for, all his hard work to be passed over to his children. And all that funding that he did should go directly to, the children of that person who worked so hard, to ensure some kind of, inheritance. But we're finding that in the process on Guam, you're paying more out of the heirs' own personal pocket sometimes, just to get things settled. And this is a step closer to providing less cost to those who are already grieving the loss of a loved one. So I thank you again. And at this time, if there's no other further questions from my colleagues, okay, then I would like to end this by having a closing from the author of the legislation. Senator Calvo, you're recognized.
So just Masi again, Madam Chair. Before I deliver my closing remarks, I just wanted to point out a few of the concerns I caught up from my colleagues. So, beneficiary may refuse the inheritance. It states in section 3383, if a beneficiary does not want the property, they can formally disclaim their interest. So that probably answers one of your questions, Madam Chair. And there's one here when we were talking about how this supersedes Senator Sean's concern. I just wanted to clarify that in Section 3373, it says there that the TOD deeds do not replace other transfer methods. The Act does not eliminate or override existing property transfer the Act does not eliminate or override existing property transfer laws in Guam. It adds an alternative option for estate planning, but does not interfere with traditional property transfers such as wills, trusts, or joint ownership arrangements. Another thing I wanted to point out is the liability for estate debts, which is in Section 3384. If the owner's estate cannot cover debts, creditors may enforce claims against the TOD property, which technically already happens now with any property holder that has mortgages or lien towards it. And if multiple TOD properties exist, debt liability is proportionally distributed among the beneficiaries. So creditors also must file claims within 18 months of owner's death. So these are the things that I kind of caught. And I just wanted to clarify it for the record so anybody who's watching can actually get an immediate answer towards the concerns. I'm going to do my closing remarks now. As we come to the close of our discussion on Bill number 2338, COR, the Uniform Real Property Transfer and Debt Act, I want to reiterate why this measure is so important for the people of Guam. We have a responsibility to remove unnecessary barriers that burden families when they are already dealing with the loss of a loved one. We have all seen or heard of cases where probate court proceedings drag on for months, even years, even decades, leaving heirs without access to their family homes, facing legal fees they cannot afford, and in some cases, being forced to sell inherited property just to settle disputes or pay legal costs. This bill provides a simple, effective, efficient, and legally sound solution, a transfer on debt deed, TOD. It allows property owners to pass their real estate to their chosen beneficiaries without probate, while still retaining full control over their property during their lifetime. It is flexible, revocable, and straightforward, ensuring that individuals can adjust their estate plans as their circumstances change. This legislation is about protecting homeownership, preserving generational wealth, and ensuring that families are not caught in legal limbo after losing a loved one. It brings fairness, clarity, and efficiency to Guam's property inheritance process and aligns our laws with best practices in estate planning across the country. By passing this bill, we are providing peace of mind to homeowners, a clear path to inheritance for beneficiaries, and a better legal framework that benefits our entire island community. I humbly ask everyone and my colleagues for your support on Bill number 23-38 COR. Let us give our people the tools they need to protect their homes and secure their families' future. Thank you very much, and Sidus Masi.
You're very welcome, Senator Calvo. And that being said, we have concluded the hearing on Bill 23-38 COR. It has been duly heard. And at this time, I'd like to move into the next bill to be heard, introduced by Vice Speaker Tony Ada. And this bill is Bill 80-38. An act to amend 3101 and 3103 of Article 1 and 3109, 3111, 3113, 3115, 3117, 3119, 3121, 3123, and 3125 of Article 2, Chapter 31, Title 15, Guam Code Annotated, relative to increasing the threshold for estates of small value by 50%. Vice Speaker Ada, you are now recognized.
Thank you, Madam Chair. Bill 80-38 increases the value of small estates in Guam's probate and estate laws with the goal of adjusting values to prevent small estates from becoming statutorily obligated for probate. Madam Chair, if Bill 80-38 COR is enacted into law, it will be the first time since enactment of Public Law 33-213 in 2016 that the value of small estates have been adjusted for inflation. This bill proposes a 50% increase in the values established by Public Law 33-213, given a conservative estimate in the annual change of the Guam Consumer Price Index, or 4.5%. The value of the price of the property should be 50% higher compared to 9 years ago. I should point out that a more realistic annual inflation rate over the past 9 years could be between 8 and 9%. Since 2021, we've emerged from the COVID-19 lockdown, and anecdotal evidence could place inflation at an average of 10 to 14% per year over the next 4 years. If 8% inflation over the last 9 years was used, the value of the property will double. Using a conservative inflation rate of 4.5%, the value of property should increase by 50%, which is the basis for the change of this bill, in this bill. Probate is an expensive process. Like Guam, all states have laws to exempt small estate from probate. Although the law does not exempt small estates from probate, creditors at any time can attach liens or collect on existing notes on the property, regardless if the estate is exempt from probate. It is my hope that when this bill, should this bill pass, that we'll be able to see it onto into the laws for our people. Thank you.
You're very welcome, Vice Speaker. And just to reiterate that Bill 80-38 received a waiver from BBMR pursuant to 12-229. Also, legal counsel has reviewed with no recommendation, changes, or amendments at this time. We also invited the Judiciary of Guam, Guam Bar Association, Public Defender, Office of Attorney General, Guam Elder Justice Center, and Department of Revenue and Taxation was invited to this public hearing. At this time, I'd like to recognize those who are here to testify. We have from the Attorney General's Office, Attorney Lee Miller. Sir, you are recognized. Please state your name and title for the record before you begin.
Good afternoon, Madam Chairman. My name is Lee Miller. I serve as the Deputy Attorney General responsible for the Civil Division at the Attorney General's Office. The Attorney General's Office is here this afternoon in support of Bill number 8038, which updates Guam's Estates of Small Value Act, which is part of the probate code. The goal is to help families settle a loved one's affairs without needing lawyers or courts. The bill raises limits, allowing more people to use the law. For example, Section 3101 increases the limit under which the law is accessible to $112,500. This mirrors California's law, which sets its limit at $166,250, and the California law adjusts every 3 years for inflation. As currently drafted, Guam's law does not include automatic inflation adjustments. However, similar to our testimony on the previous bill, it is important to understand the responsibilities when using these laws. Section 3121 makes recipients personally liable for the deceased's debts up to $112,500. Even if someone inherits benefits like pensions or bank accounts, they may need to cover debts of the deceased, such as medical bills, later on. We recommend anybody taking advantage of the law receive some legal advice to avoid financial pitfalls. The legislation provides helpful updates, but understanding the law is key to using them wisely. Thank you for the opportunity to comment on this legislation.
Thank you, Attorney Miller, and thank you so much for being here today to testify. At this time, I'd like to have the sponsor open up with any questions.
Thank you, Madam Chair. I don't have any questions, but I do thank the attorney for coming down and testifying on both bills on behalf of the Attorney General, Doug Moylan. And I think it's always prudent to say that legal advice is always recommended, and that these types of legislations are helpful for our people, and it just avoids the courts and lawyers when these estates are so small that it's more beneficial to the owners, and they don't lose that much from going to court or paying attorney fees. So thank you, Attorney Miller, for coming down to testify on behalf of both bills, and we appreciate your testimony today.
Thank you, Senator or Vice Speaker. At this time, I would like to open up to Senator Shelly Calvo.
Thank you, Madam Chair. I just want to thank Attorney Miller for being here and for all your testimonies and guidance on, especially for my other bill, the earlier bill. But to just Mase for your time and your effort and your energy, and thank you so much, Madam Chair. I really don't have any question regarding this bill. I think this is a well-intended bill.
Thank you, Senator Calvo. Senator Gumatauta, you are recognized.
Thank you, Madam Chair, and thank you again, Lee, for being with us today. I only have just a couple of questions, and I mean, I'm in support of this one and the previous, but just wanted to ask, what information is available regarding the possibility of adjusting the small value thresholds impacted by Bill 80-38 without legislation moving forward, perhaps tying future increases to changes in the consumer price index?
Madam Chair, Senator Gumatautau, Guam's law on these estates of small value was taken from California law. California law has included in it a statutory obligation of the California Budget Office to every 3 years to calculate the rate of inflation from the last adjustment to 36 months later, and the California Budget Office simply publishes a notice that says, we take the baseline, we grow it by the rate of inflation, and here's the new baseline, and no legislative action is required to change the number. Budget Office simply informs the judiciary and sends a letter over to the California Bar Association, and everybody operates under the new number.
Which is a kind of a good segue to my second question. I think you might have answered it. So I'm asking, how helpful could it be if the legislature considered creating and designating maybe an independent group of attorneys and economists to propose future increases to policymakers maybe every 5 to 10 years, and for the recommendations to be automatically adopted if no action is taken by the legislature within 90 days of receipt?
Madam Chair, Senator, there's a wide variety of mechanisms, excuse me, the legislature could craft to come up with these adjustments. The most accessible one is just look up how California has done this and copy what California has already done. But we are happy to consult with you and the chair and the sponsor on whatever type of mechanism the legislature thinks most appropriate to make sure it's good public policy to move these numbers around.
All right, thank you, Lee, and thank you, Madam Chair. Again, I'm in support of this bill and the previous. Thank you so much.
Thank you, Senator Gumatautau. Senator Borja, you are recognized.
Thank you, Matt. Thank you, Madam Chair. No questions. Of course, I support the proposal, and this is good policy that really modernizes the outdated thresholds and reduces a lot of the red tape. Thank you to the Attorney General's office for coming down and supporting this as well, and I look forward to seeing this measure and its passage. Thank you, Madam Chair.
Thank you, Senator Borja. Attorney Miller, I appreciate you being here, as well as my colleagues. You're the only one here. I'm hoping to get in and out of this public hearing right away. But, this is very important. There's a lot of people who have been texting me who are watching this public hearing because, it deals a lot with their families. And, of course, this bill is just an excellent bill when it comes to assisting, especially when it comes to smaller states. But can you give me for the layman who's watching, why the 50% was utilized, or what does this actually help, a person taking advantage of this legislation? In layman's terms, because someone is texting me saying that, well, what exactly does this do? Yeah.
Madam Chair, members.
As an example, you can give an example. Thank you.
Perhaps the most obvious example I could give you is where a government of Guam employee has a pension account while they're receiving benefits from that pension. There is a principal amount, and that principal amount they've authorized that principal amount to continue to be invested, and up until very recently, the stock market was doing very well in the United States, and those pension accounts were getting bigger every year. And somebody who, when they retired from the government of Guam, the value of their pension account may have been under $75,000 when they finally pass and somebody in the family goes and looks, can we go and collect the death benefit under that pension account because of the past several years, growth of the stock market, now that account is worth more than $75,000. If this bill doesn't pass, that estate will have to be probated in order to collect that amount. And so there are similar types of assets that we've had where, frankly, just the market inflation has pushed the value of the asset up beyond what we paid for it way back when, and now we're over $75,000. And if the bill doesn't pass, we'll be going to probate with those assets.
So it has to do a lot with taxes, especially on taxing. They caught the capital.
Well,
Because if you're looking at funding, you're talking about also, having to bar that against taxes as well. Is that correct?
usually not, Madam Chairman.
Okay.
Under American tax law, whatever the asset used to be worth, for tax purposes, we change the value of the asset for estate tax purposes, only estate tax purposes, to the value of the asset on the day the owner passes. The best example I can give you of what I'm talking about there is farmland. If I paid $10,000 an acre for some farmland way back when, it's carried on the books of my farming company at $10,000 an acre, but I pass tomorrow, and tomorrow's value is actually $100,000 an acre. There is no capital gain on the difference between $10,000 and $100,000 because American tax law says, nope, move the value for estate tax purposes to the value on the day I passed. So the value would automatically shift from $10,000 an acre to $100,000 an acre, no capital gain, no estate taxes to pay.
And this has nothing to do with the 50% that we're talking about today.
No, what the bill in front of us has to do with our other assets, stock accounts, pension accounts, bank accounts. If we had a partnership interest in a business, if I and a couple of fellows all owned a construction business together, and we were each 33% partners in the business, that 33% is worth something, certainly worth something to my family. And so if it today, if it's worth $75,000, or if the bill passes, if it's worth $112,500, we wouldn't have to go through the effort of probate in order to convert my 33% interest in the business into some cash that would pass to my heirs. We'd simply go to my two surviving partners and say, hey, fellas, it's time to buy the estate out and take that 33%, turn it into cash, as long as that interest was worth under $112,500. We wouldn't have to do all the probate rigmarole to just move that value into the family.
Which is something that I think is an excellent idea to do. This bill, I stand in full support of this legislation, and I'm going to do everything I can to get that committee report out and get it into the next session agenda. And at this time, thank you for answering my question. I'd like to have the author of the legislation close on his legislation.
Thank you, Madam Chair. Just like to thank again Attorney Miller for coming down and testifying on behalf of Attorney General Doug Moylan. And I look forward to having this bill go to the session floor as soon as we can. Thank you, Madam Chair.
You're very welcome, Vice Speaker. And as I mentioned, there's a lot of families out there that have to deal with this type of, foreseeable, people pass on, but the cost, and especially during a time like that, have to be burdened with additional cost, or it's something that we can do to avoid at this legislature. So appreciate it. Again, thank the Attorney General for providing his testimony and for sending you here to answer our questions. Greatly appreciate it. And at this time, we can say that it has been duly heard, that Bill 80-38 has been heard, and this will conclude the public hearing. My office will continue to accept written testimony on today's hearing within 5 business days, which may be mailed to my office at 238 Archbishop Flores Suite 407 of the DNA Building in Hagåtña. You may also send your written testimony to my office via email, senatortelot@gmail.com. Thank you for participation and create a great day. The time now is 3:06 p.m. Si Diyos masi. Thank you.